Constitution of India. Introduction. Majority of the countries throughout the world have a basic document of governance known as Constitution. The Constitution of a country is the fundamental law of the land on the basis of which all other laws are made and enforced. It sets out the framework and principal functions of the organs of the government within the state and declares the principles by which these organs must operate. Every organ of the state, be it the executive or the legislative or the judiciary, derives its authority from the Constitution, and there is no authority, department or branch of the state, be it the executive or the legislative or the judiciary, which is above or beyond the Constitution or has powers unfettered and unrestricted by the Constitution. The Constitution has devised a structure of power relationship with checks and balances, and limits are placed on the powers of every authority instrumentally under the Constitution. Thus, a Constitution is considered as the supreme or as fundamental law of the land, which sets out a framework and principal functions of the organs of the government as well as the extent of its sovereign power and manner of its existence. It enjoys sanctity and also contains the faith and aspirations of the people. The Constitution acts like a vehicle of nation's progress. So, the Constitution of India. It is the supreme law of the India. It lays down the framework defining fundamental political principles, establishes the structure, procedures, powers and duties of governmental institutions, and sets out fundamental rights, directive principles and the duties of citizens. It is the longest written constitution of any sovereign country in the whole world. Dr. Bhimrao Ramji Ambedkar, the chairman of the drafting committee, is widely considered to be its chief architect. So over here you can see this is a picture of Dr. Bhimrao Ramji Ambedkar right in front of you. Further, a Constitution of India imparts constitutional supremacy and not parliamentary supremacy, as it is not created by the parliament, rather by a constituent assembly, and which was adopted by its people with a declaration in its preamble. Parliament cannot override the Constitution. It was adopted by the Constituent Assembly on 26th November 1949 and came into effect on 26th January 1950. With its adoption, the Dominion of India became modern and contemporary Republic of India, replacing the Government of India Act 1935 as the country's fundamental governing document. To ensure constitutional autonomy, the framers of the Constitution repealed the prior acts of the British Parliament via Article 395 of the Constitution. India celebrates its coming into force on 26 January each year as Republic Day. It declares India a sovereign, socialist, secular, democratic republic, assuring its citizens justice, equality, liberty and endeavors to promote fraternity among them. Now let's come on salient features. So in these salient features I would be covering 26 points. So let's move on. First, written and detailed constitution. The constitution is a completely written document which incorporates the constitutional law of India. It was fully debated and duly enacted by the Constituent Assembly of India. It took the Assembly 2 years, 11 months and 18 days to write and enact the constitution. Indian constitution is a very detailed constitution. It consists of 395 articles, which are further divided into 22 parts with 12 schedules and 101 constitutional amendments till now. It is a constitution of both the center and states of Indian Union. It is indeed much bigger than the US Constitution, which has only 7 articles, and the French Constitution with its 89 articles. Second, self-made and enacted constitution. Our Indian Constitution is a constitution made by the people of India acting through their duly elected representative body known as a Constituent Assembly, which came into being in December 1946. Its first session was held on 9th December 1946. It passed the objective resolution on 22nd January 1947. Thereafter, it initiated the process of constitution making and came in a position to finally pass and adopt the constitution on 26th November 1949. The constitution became fully operational with effect from 26th January 1950. As mentioned earlier, we celebrate this day as a Republic Day. The Constitution of India is thus a self-made and duly enacted constitution. Third, Preamble of the Constitution. The Preamble to the Constitution of India is a well-drafted document which states the philosophy of the Constitution. It declares India to be a sovereign, socialist, secular, democratic republic and a welfare state committed to secure justice, liberty, equality for the people and for promoting fraternity, dignity of the individual and unity and integrity of the nation. The preamble is the key to the Constitution. It states in a nutshell the nature of Indian state and the objectives upon which it is committed to act. So over here I have given you the image of our preamble. So we can clearly read by this image that it states that we the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure to all its citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact and give to ourselves this Constitution. So our fourth point is India is a democratic socialist state. Although from the beginning, the Indian Constitution has fully reflected the spirit of democratic socialism. It was only in 1976 that the preamble was amended to include the term socialism. It is now regarded as a prime feature of Indian state. India is committed to secure social, economic and political justice for its entire people by ending all forms of exploitation and by securing equitable distribution of income, resources and wealth. This is to be secured by peaceful constitutional and democratic means. Fifth, India is a secular state. So India gives special status to no religion. There is no such thing as a state religion of India. This makes it different from theocratic states like the Islamic Republic of Pakistan or other Islamic countries. Further, Indian secularism guarantees equal freedom to all religions. The Constitution grants the right to religious freedom to all the citizens of India. So I have given a picture over here. By this image you can see that Hinduism, Jainism, Buddhism, Sikhism, Islam, Christianity, be it any religion, India does not give any special status to any sort of religion. Everyone is treated as one. So our sixth point is India is a democratic state. The Constitution of India provides a democratic system. The authority of the government rests upon the sovereignty of the people. The people enjoy equal political rights. On the basis of these rights, the people freely participate in the process of politics. They elect their representatives, which further forms the government. Free, fair and regular elections are held for electing representatives for all its activities. The government of India is responsible before the people. The people can change their government through elections. No government can remain in power which does not enjoy the confidence of the people. That's why India is world's largest working democracy. Seventh, India is a republic. Our preamble declares India to be a republic. India is not ruled by a monarch or a nominated head of state. India has an elected head of state, President of India, who wields power for a fixed term of 5 years. After 5 years, the people of India indirectly elect their president. So right now we are having 14th President of India, who is Shri Ramnath Kovind ji. 8th, India is a union of states. Article 1 of the Constitution declares that our India, that is Bharat which is known in Hindi, is a union of states. The term union of state shows two important facts. First, the Indian Union is not the result of voluntary agreement among sovereign states. Second, that states of India do not enjoy the right to secede from the Union. Indian Union has 29 states and 7 union territories. 9th, mixture of federalism and unitarianism. While describing India as a union of states, the Constitution provides for a federal structure with a unitary spirit. Scholars describe India as a quasi-federation or as a federation with a unitary bias, or even as a unitarian federation. Like a federation, the Constitution of India provides for, first, a division of powers between the center and states. Second, a written, rigid and supreme constitution. Third, independent judiciary with the power to decide center-state disputes. And fourth, dual administration, that is, central and state administrations. However, by providing a very strong center, a common constitution, single citizenship, emergency provisions, common election commissions, common all India services, etc., the Constitution clearly reflects its unitary spirit. India is a federation with some unitarian features. This mixture of federalism, unitarianism has been done keeping in view both the pluralistic nature of society and the presence of regional diversities, as well as due to the need for securing unity and integrity of the nation. 10th, mixture of rigidity and flexibility. The Constitution of India is rigid in parts. So let's see how it is rigid in parts. Some of its provision can be amended in a difficult way while others can be amended very easily. In some cases, the Union of Parliamentarians can amend some part of the Constitution by passing a simple law, whereas Article 368 of the Constitution provides for two special methods of amendment, as per which, first, most of the provisions of the Constitution can be amended by the Union of Parliamentarians by passing an amendment bill by a majority of total membership and a two-third majority of members present and voting in each of its two houses, that is Lok Sabha and Rajya Sabha. Second, for the amendment of some specified parts, a very rigid method has been provided. Under it, first, the Union of Parliamentarians passes the amendment bill by a majority of total membership and a two-third majority of members present and voting in each house. And then it goes to the state legislatures for ratification. The amendment gets passed only when it is approved by not less than one half of the states of the Union. Thus, the Constitution of India is partially rigid and partially flexible. 11th. This is the most important salient feature of Indian Constitution, fundamental rights. Under the Part 3 of Constitution, which covers Article 12 to 35, the Constitution of India grants and guarantees fundamental rights to its citizens. Initially, 7 fundamental rights were granted, but after the deletion of the right to property from the list of fundamental rights, as per 44th Amendment Act 1979, their number came down to 6. So I have laid down the 6 fundamental rights, as per which first right is right to equality. Right to equality, it provides for equality before law, end of discrimination, equality of opportunity, abolition of untouchability, and abolition of titles. Second, right to freedom. Right to freedom incorporates 6 fundamental freedoms: freedom of speech and expression, freedom to form associations, freedom to assemble peacefully without arms, freedom to move freely in India, freedom of residence in any part, and freedom of adopting any profession or trade or occupation. This right ensures personal freedom and protection in respect of conviction for certain offences. The Constitution lays down the freedom of life and liberty, which cannot be limited or denied except in accordance with the procedure established by law. Now, under Article 21A, right to education for the children between the ages of 6 to 14 years has been granted by the Government of India. Article 22 guarantees protection against arbitrary arrest and detention. Third, right against exploitation. This fundamental right prohibits sale and purchase of human beings or human trafficking, forced labor, and employment of children in hazardous jobs and factories. Fourth, right to freedom of religion. This right grants this right involves the freedom of conscience, religion, and worship. Any person can follow any religion. It gives to all religions freedom to establish and maintain their religious institutions. No person can be compelled to pay any tax for the propagation of any religion. The state cannot levy a tax for any religion, and Constitution prohibits the imparting of religious instructions in schools and colleges. Fifth, cultural and educational rights. Under this category, the Constitution guarantees the rights of the minorities to maintain, and develop their languages and cultures. It also confers upon them the right to establish, maintain, and administer their educational institutions. Sixth, right to constitutional remedies. Article 32. This fundamental right is the soul of the entire rights. It provides for the enforcement and protection of fundamental rights by the courts. It empowers the Supreme Court and the High Court to issue writs for the enforcement of these rights. 12th, National Human Rights Commission (NHRC) and State Human Rights Commission and Protection of Human Rights. With a view to protect the human rights of all the people, the Protection of Human Rights Act 1993 was passed by the Union of Parliamentarians. Under it, the National Human Rights Commission was established. It is headed by former Chief Justice of India. It acts as an independent commission with the status of a civil court. It works for preventing the violations of human rights of the people. It acts on proved violations of human rights. The NHRC can order the grant of compensation to the victims. Several state human rights commissions are also working for the protection of human rights. India is fully committed to protect the human rights of all the people of its nation and the world. So here is the logo of NHRC. 13th, Fundamental Duties of the Citizens. In its part 4A, which is Article 51A of the Constitution, describes the following fundamental duties of a citizen. First, respect for the Constitution, the national flag, and the national anthem. Second, cherish the noble ideals of the freedom struggle. Third, uphold and protect the sovereignty, unity, and integrity of India. Defend the country and render national service when called. Promote the common brotherhood of all the people of India and renounce any practice derogatory to the dignity of women. Preserve the rich heritage of the nation's composite culture. Protect the natural environment and have compassion for living creatures. Develop scientific temper, humanism, and spirit of inquiry and reform. Safeguard public property and abjure violence. And strive for excellence in all individuals and collective activity. Duty of the parents to send their children to schools for getting education. The fundamental duties are, however, not enforceable by the courts. 14th, Directive Principles of State Policy (DPSP). Part 4 of the Constitution deals with the Directive Principles of State Policy. It provides one of the most striking features of the Indian Constitution. The Directive Principles are instructions to the state for securing socio-economic developmental objectives through its policies. These are to be implemented by both the Union, Lok Sabha and Rajya Sabha for the states. For example, Directive Principles direct the state to ensure for the people adequate means of livelihood, fairer distribution of wealth, equal pay for equal work, protection of children, women, labor, youth, old age pension, social security, local self-government, protection of the interest of the weaker sections of society, promotion of cottage industries, rural development, international peace, friendship and cooperation with the other states, etc. The aim of Part 4 is to secure and strengthen socio-economic democracy in India. 15th, Bicameral Union Parliament. The Constitution provides for a bicameral legislature at the union level and names it as the Union Parliament. Its two houses are the Lok Sabha and the Rajya Sabha. The Lok Sabha is the lower, popular, directly elected house of the parliament. It represents the people of India. Its maximum strength stands fixed at 550. Presently, Lok Sabha has 545 members. The people of each state elects representatives in proportion to their population. Members of the Lok Sabha are directly elected by the people of India. All men and women of 18 years or above of age whose names are registered in the voters list can vote in elections for electing the members of Lok Sabha. Every voter of 25 years or above of age is eligible to contest elections to the Lok Sabha. The tenure of the Lok Sabha is 5 years, but the President, acting under the advice of Prime Minister, can dissolve it earlier also. Now, whereas the Rajya Sabha is at the upper hand, indirectly elected a second house of parliament. It represents the states of the Indian Union. Its maximum membership can be 250. Presently, the Rajya Sabha has 245 members. Out of these, 233 members are elected by all the state legislative assemblies and 11 are nominated by the President from among eminent persons from the fields of art, science and literature. Rajya Sabha is a quasi-permanent house. Its one-third members retire after every 2 years. Each member has a tenure of 6 years. Out of the two houses of parliament, the Lok Sabha is a more powerful house. It alone has financial powers. The Union Council of Ministers is collectively responsible before the Lok Sabha. However, the Rajya Sabha is neither as powerless as the British House of Lords and nor the Lok Sabha is as powerful as the British House of Commons. So I have given two pictures over here. On the left hand side you can see this is the image of Lok Sabha, and on the right hand side this is the picture of Rajya Sabha. So you can observe what is the difference between both of them. 16th, Parliamentary system. The Constitution of India provides for a parliamentary system of government at the center as well as in every state of the Union. The President of India is a constitutional head of state with nominal powers. The Union Council of Ministers, headed by the Prime Minister, is the real executive. Ministers are essentially the member of the Union Parliament. For all its policies and decisions, the Council of Ministers are collectively responsible before the Lok Sabha. The Lok Sabha can remove the ministry by passing a vote of no confidence motion. The cabinet, in fact the Prime Minister, has the power to get the Lok Sabha dissolved by the President. On similar lines, a parliamentary government is also at work in each state. So here is a picture of our Parliament of India. 17th, Adult suffrage. Another feature of the Constitution is that it provides for universal adult suffrage, which means all men and women enjoy an equal right to vote. Each adult man and woman above the age of 18 years has a right to vote. All registered voters can get the opportunity to vote in elections. 18th, Single integrated state with its single citizenship. India is the single independent and sovereign integrated state. Presently, it has 29 states and 7 union territories. All citizens of India enjoy a common uniform citizenship. They are entitled to equal rights and freedoms and equal protection of the state. 19th, Single integrated judiciary. The Constitution provides for a single integrated judicial system, common for the Union and the states. The Supreme Court of India works at the apex level, High Court at the state level, and other court works under the High Courts, which are known as district courts. 20th. Independence of judiciary. The Indian Constitution makes judiciary truly independent. It is clear from the following facts that judges are appointed by the president. Only persons with high legal qualifications and experience are appointed as judges. Judges of the Supreme Court cannot be removed from office except through an extremely difficult process of impeachment. The Supreme Court has its own staff. Indian judiciary has an autonomous organization and status. It works as an independent and powerful judiciary. 21st. Judicial Review. The Constitution is the supreme law of the land. The Supreme Court acts as the guardian, protector, and interpreter of the Constitution. It is also the guardian of the fundamental rights of the people. For this purpose, it exercises the power of judicial review. By it, the Supreme Court determines the constitutional validity of all laws made by the legislatures. It can reject any law which is found to be unconstitutional. 22nd. Judicial activism. Currently, Indian judiciary has been becoming more and more active towards the performance of its social obligations through public interest litigation system (PIL), as well as through a more active exercise of its powers. The Indian judiciary has been now very actively trying to secure all public demands and needs due to them under the laws and policies of the state. 23rd. Emergency provisions. The Constitution of India contains special provisions for dealing with emergencies. It recognizes three types of possible emergencies. First, national emergency. It is mentioned in Article 352. An emergency resulting from war or external aggression or threat of external aggressions against India or from armed rebellion within India or in any of its part. Second, constitutional emergency in a state. It is laid down under Article 356. An emergency resulting from the failure of constitutional machinery in any state or some states. And third, financial emergency. It is laid down under Article 360. An emergency resulting from a threat to financial instability of India. The President of India has been empowered to take appropriate steps for dealing with these emergencies. During the period of an emergency, the powers of the President, actually of the PM and the Union Council of Ministers, Cabinet, increased tremendously. President can take all the steps deemed essential for meeting an emergency. These are called emergency powers of the President. 24th. Special provisions relating to scheduled castes, SCs, and scheduled tribes, STs, with a view to protect the interests of people belonging to scheduled castes and scheduled tribes. The Constitution lays down certain special provisions. It provides for reservation of seats in the legislatures for the people belonging to the scheduled castes and scheduled tribes. President can nominate in Lok Sabha not more than 2 members of the Anglo-Indian community in case he is of the opinion that this community is not adequately represented in the House. Reservation of some jobs for the people belonging to SCs, STs and OBCs has also been in operation. The reservation system has been now extended up to the year 2020. 25th. Provisions regarding language. The Constitution has laid down special provisions for defining the language of the Union, regional languages, and languages of the Supreme Court and High Court. It states that the official language of Union shall be Hindi in Devanagari script. But along with this, it also provides for the continuance of English language. A state legislature can adopt the language of the province as its official language. In India, English continues to be the language of the Supreme Court and the High Court. The Constitution gives a directive to the Union to develop Hindi and popularize its use. In the Constitution 8th schedule, the Constitution recognizes 22 modern Indian languages, which includes Assamese, Bengali, Gujarati, Hindi, Kannada, Kashmiri, Malayalam, Marathi, Oriya, Punjabi, Nepali, Manipuri, Konkani, Sanskrit, Sindhi, Tamil, Telugu, Urdu, Bodo, Dogri, Maithili, and Santhali. 26th. A constitution drawn from several sources. In formulating the Constitution of India, the founding fathers used several sources. The values and ideals of the national movement guided their path. The national movement influenced them to adopt secularism as the ideal. Some provisions of Government of India Act 1935 were used by them, and several features of foreign constitutions influenced them and were adopted by them. In adopting parliamentary system and bicameralism, the British Constitution influenced them. The US Constitution influenced them in favor of republicanism, independence of judiciary, judicial review, and Bill of Rights. The progress of the former USSR after the 1917 Socialist Revolution influenced them to adopt socialism as a goal. Likewise, they were influenced by the constitutions of Canada, Australia, Weimar, Republic of Germany, and Ireland, respectively. With all these features, the Indian Constitution is a constitution best suited to the Indian environment. The Constitution has been helping India to organize and run the government and administration in an effective way, both in times of peace and war. The basic structure of the Constitution, that is, its most fundamental features, can be described as preamble, fundamental rights, directive principles, secularism, federalism, republicanism, independence of judiciary, rule of law, and liberal democracy. Thank you for watching. Do like and subscribe. Thank you and have a nice day.